Okay, we have question 3 from 2016 February bar exam, professional responsibility. It looks like it's got 3 calls of the question, so you will always want to number it exactly the way I have it. So, the lawyer committed any ethical violations by agreeing to represent contractor. So we have contractor. Number 2, did the lawyer commit any ethical violations by failing to make the court appearance? Court appearance. And number 3, what should lawyer do with the money in the client trust account? Okay, so those are our 3 topics. Not too hard. Generally, when you get 3 calls of the question, the most important call is going to be the first one or the second one, or generally the first and the second one. And when there's multiple calls of the question, the examiners usually leave. They know they're not trying to backlog. They're not trying to put things at the end. They front load all the information. So, because they know you're going to be running out of time, so they put the most important information in the beginning so that you can fully analyze it and discuss it in a lawyer-like manner and see if you actually do have the minimum competence to pass. So instead of rushing to finish, take your time. I always say use the 45-15 rule. Spend the first 45 minutes doing the best you can, putting your best foot forward, writing it as strongly as you can, taking the time to read the fact pattern slowly and carefully a few times, and then when you need to wrap up, the last 15 minutes, just wrap up. You can actually get through questions 2 and 3 in the last 15 minutes, but you don't know that at first. So take your time to go through it. In fact, if you want to see something cool, one of I believe it was this essay, it was the end of selected answer B on the State Bar's website is a great example of how to wrap up when time is short. The student was able to answer the final 2 calls in a short and concise manner. And that's a published answer that received a perfect score. So if you think you need to make these long-winded legal arguments, just get to the point of what it is. And I always say, get to the heart of it. So if you spend 45 minutes here, that's fine. 15 minutes here, actually you probably only need 10 minutes here, to be honest with you. Okay, now one of the things I wanted to show you too, the examiners usually do this, and nobody really ever sees it. So while this may seem like a big fact pattern, believe it or not, and I might need a close-up here, it's actually 3 mini essays. Call number 1, I'll make notes right here. 1. The first paragraph goes entirely to call 1. The second paragraph goes entirely to call 2, and the third paragraph to call 3. So you just break it up. That's all it is, because call 1 deals with contractor, call 2 deals with the court appearance, which is in the second paragraph, and call 3 deals with the client trust fund, which is in the third paragraph. Okay, let's take a look. Let's go through it. We'll break it down one by one. Contractor and lawyer have been in a consensual sexual relationship for months. So, we have sex with a client. And that's allowed as long as there's a prior existing relationship. Even though you're allowed to have sex with a client when there's a previous existing relationship, you've got to be careful though, because think about it. They've only been dating, it says they've been in consensual sexual relationship for months. Because they've been dating only for a few months, the relationship is relatively new. So there's a potential that down the road something might go wrong. And if that happens, you're going to have a conflict with your personal interests. And because of that conflict, you may not be able to represent the client competently. See, if you actually slow down and think, all the issues just come right to you. Contractor cannot afford to hire an experienced lawyer to defend him against plaintiff's complex construction defect case. A complex construction defect case. Does anybody have any idea how long this case is going to last? If you got out of this case within 5 years, you'd be lucky. So you know it's going to, guess what? I have a feeling this case is going to go a lot longer than their relationship. So, and you might want to think about that. Wait, should I really represent this person in this elongated lawsuit where we could be broken up in a few extra months? I mean, everything looks peachy keen now, but it might fall apart down the road. Okay. So, contractor told lawyer who had never handled such legal matters. Okay. Are you competent? So, new type of case. that he wouldn't sue her for malpractice if she would defend him for half her regular rate. Lawyer felt pressured because of the relationship. So let's take everything in context here. Okay, sex with a client, conflict of personal and potential conflict. And let me ask you this. Is a reasonable lawyer would say, yeah, you can probably do that? Probably. I mean, yeah, and if a conflict, I mean, later comes down the road, you might have to, you know, swap out counsel or withdraw or something like that, which is not good, which you should think about in the beginning. But there is a potential conflict with the lawyer's own personal interests. All right, we know she's really emotional too. We find that out later on. So the contractor never handled such matters. So it's a new type of case, but lawyer can become competent by requiring the type of skill, intelligence, competence, like associating with another attorney of like somebody who's done construction defect law for a while, maybe associating with another firm, studying on it, any type of preparation, being thorough, looking through everything. There's a million ways to be competent. When it says contractor told lawyer that he wouldn't sue her for malpractice, okay, so now we're limiting malpractice liability. A lot of things going on in this first paragraph. That's why it's important to read it carefully and read it thoroughly. So essentially, a lawyer cannot prospectively limit liability for malpractice. So you can't get advanced consent for incompetent representation. By the way, there's no breach of the duty of competency. And by the way, it turns out that lawyer probably was competent because was able to win $100,000, which we later find out. You have to tie it together though. Okay. So now it said, continuing on. Lawyer felt pressure because of the relationship. Because of the pressure, there's potential conflict. Like, is the fact that like I'm only taking this representation? Is she only taking this representation because he pressured her because they were dating to represent him in this case? So the fact that she feels pressure should say that we have a potential conflict, and maybe a reasonable lawyer might find it to be unconsentable. Again, we don't know how that's actually going to play out. You actually have to determine for yourself however conclusion you want to come through, but definitely it's the process, not the conclusion that matters, the discussion of it. Lawyer told contractor that she would defend him for half price. Okay, so now we have an oral fee agreement. And it turns out not all of paragraph 2 goes to, like half of paragraph 2 goes to call 1, the other half goes to call 2. So I should have made that exact, dead set line, but you kind of get the gist of what I'm trying to say. So an oral fee agreement. ABA prefers a writing. California, if over $1,000. And guess what? This is likely going to be over $1,000 because we're talking about a complex construction defect case. So lawyer told contractor, and that's the oral part, that she would defend him for half price, but she would only bring his cross complaint. There are 2 different agreements. There's the defense one and there's the cross complaint. So this is the cross complaint, and now, this is the defense. And here, the cross complaint turns out to be a contingency fee agreement. That's where they ultimately get the $100,000. And contingency fee agreements must be in writing. They must also be reasonable. Of course, all fees must be reasonable. And they must state what percentages, what the lawyer's percentages, 30, 40%, whatever it may be, and whether or not that's going to be taken out before or after expenses. And also the agreement must state what expenses the client is going to be liable for. So, we have the defense, because don't forget, it's contractor who's being sued. So contractor has to defend. You can't take a contingency on a defense case because you're the one who's being sued. You're not going to win any money in defense, but we have the contingency on the cross complaint. So the oral fee agreements for the defense, the contingency fee, which is fine in the ABA, not in California. The contingency fee agreement violates both ABA and California because it wasn't in writing. We don't know whether or not it's reasonable. It probably is. We have no facts to kind of determine that, and whether or not the percentages or anything else were laid out. Because all that stuff wasn't laid out, we probably have a violation. Again, it says, we'll only bring the cross complaint and a contingency at a regular rate of 30% of any recovery. And it does seem like a contingency fee agreement is proper in this case. It's not for a domestic matter where you're trying to secure a divorce or alimony or property received in a divorce, and it's definitely not a criminal case. All right, contractor agreed. Although they continue to have a sexual relationship, their personal relationship deteriorated. So that all really kind of goes to paragraph, to call number 1. So their personal relationship deteriorated, and that was the potential conflict with your personal interest that this might happen. Now, lawyer forgot to make a scheduled court appearance. Well, by not making a scheduled court appearance, he didn't act competently or diligently. Because don't forget, one of the things with the rule for conflicts of interest is whether or not competent and diligent representation could still be undertaken. And that's when we get these two issues. Competent attorney would have showed up. Diligent, can't unnecessarily, unduly delay. There you go. So that's what's going on in call number 2. And call number 3, which is the third paragraph. At trial, plaintiff lost, and contractor won $100,000 cross complaint. Turns out, it seems like lawyer was pretty competent, at least in the beginning, because they somehow handled the matter pretty swiftly, and they ended up winning for their client, so that was nice. Contractor won $100,000 on his cross complaint. Got it? Lawyer deposited the $100,000 in her client trust account, which is good. You have to keep your the lawyer's property and the client's property separate. Cannot commingle. She told contractor she would send him $70,000. Okay, that means she's probably taking out 30%, so that means the fee probably was reasonable. Fair enough. But it wasn't in writing. Contractor said lawyer must send an additional $15,000 because she agreed to represent him for half price on everything, including the contingency fee. Did she say that? She did say she would defend him for half price, but she would only bring a cross complaint on contingency at a regular rate of 30%. So the client's confused. The client's like, wait a second, did you say half price of your regular rate of 30% or half price just for the defense? See, it wasn't clear. It wasn't in writing, hence why we'll have a dispute about the amount of money to receive. So we have disputed funds. Disputed funds. Contractor said lawyer must send the additional $15,000 because she agreed to represent him for half price and everything, including the contingency fee. Don't know whether or not contractor's claim is actually correct. He may or may not be right on that. She might have meant whatever. So now we have a disputed amount. We need a third party, someone to come in and actually arbitrate this, mediate this, figure out what's the reasonable solution. So here's the thing. We know out of the $100,000 that goes in the client trust account, lawyer thinks she's entitled to 30%. Contractor thinks she's entitled to 15%. Nevertheless, 15%, $15,000 of it is for lawyer. That goes without saying. So the lawyer may take that money and now put it in her personal account, may go down and bet the ponies, may bet on the Saints next week against the Eagles, who knows. Okay, so $15,000 goes to the lawyer. At least, yeah. Now, the $70,000, that goes to client because that's completely undisputed. There's neither lawyer nor client would disagree with the fact that, hey, look, this $70,000 is a client because lawyer even agrees, client agrees. But now we have a $15,000 that is disputed. That's whether or not the half price was there. So this must be in the trust account. So lawyer can take $15,000 for herself, must send $70,000 to the client promptly, and must keep the rest of the $15,000 in the trust account and let some neutral third party determine whether it's a court, whether it's an arbitrator, no matter who it is, settle the dispute. Okay, so let's do a recap here. So we have sex with the client and the potential conflict of interest with the personal interest, and it may or may not be consentable, depending on how a lawyer felt. Don't forget, she felt pressured by taking this case. Competent was a new type of case, so she has to handle the legal problem with the required preparation and study and employ the requisite knowledge and skill in the matter. And here we have, okay, so that's for competency. Limiting malpractice liability, you just can't do it. You can't get advanced consent for incompetent representation. The oral fee agreement, ABA prefers that it's in writing. California, if it's over 1,000, and clearly it's likely to be over 1,000. Contingency fee agreement, that wasn't in writing, so we have a problem there. And finally, for the number 2, the duty of competence, failed to perform competently by not showing up for court. Wasn't diligent because you've got to make a scheduled court appearance, and was not prompt and diligent in the representation of her client. And finally, with the client trust account, the disputed money stays in the trust account. The undisputed money that's owed to the client goes to the client. The undisputed money that's owed to the lawyer goes to the lawyer. Simple as that. All right, and that's it. That's a wrap. This is actually an essay that encompasses many of the more commonly tested issues. Fee agreements, conflicts of interest, very heavily tested. Competence and diligence also. All right, so there you go. That's 2016, February, question 3, professional responsibility.